And welcome to this episode of the Good Citizen Podcast. Well, as I mentioned last week, it is conference season. Had a chance to speak to a conference of pastors, and then this week to a group of school leaders at the Principals Clinic in Pensacola, Florida. Such an incredible event with school leaders from across the United States and even 9 different countries. So many encouraging discussions. I'm going to save one of those to the end. This was such an inspiration to me. I think it'll be an encouragement to you as well. So look forward to sharing that at the end of this episode. But while I was here in Florida, I had an opportunity to visit the Florida State House. And I know some of you might be thinking, you are such a citizenship nerd, interested in public life. Only those types of folks would go to Florida and then go to the State House in Tallahassee. But it is a remarkable building. It looks more like a skyscraper than a traditional state house. But I appreciate my colleagues there at the Florida Family Voice. That would be the folks in the family affiliated policy group here in Florida, being there, giving me the tour. And while I was there, I'll have to share this. So if you're over on YouTube, and maybe if you're just listening, at some point you want to jump on over to YouTube, you can see this. But in the Florida State House, I found the most passive-aggressive plaque that I have ever seen in a state house. So today we're going to be talking about legal challenges in Christian education. That's our first slide. But I have a picture here of the Florida State House. It looks a little bit like a skyscraper, massive, a lot of floors. But then as you kind of come into the elevator bank, there is a plaque. Now, you have to understand, I guess as Florida grew, it grew from the north kind of into the south. So the political power was often there in the north, and so Tallahassee is in North Florida. And so apparently there's a senator named Lee Weisenborn who attempted to move the state house down to Orlando or down to central Florida, where you think, okay, we've got Miami in the very south. And so he attempted to move that. Well, the political power, those in the north, pushed back against him, and their way of making sure that the capital never moved was to build this massive state house. And so there's a plaque. This is just fantastic. There's a plaque. It just says, this plaque is dedicated to Senator Lee Weisenborn, whose valiant effort to move the capital to Orlando was the prime motivation for construction of this building. And so they put up a plaque for the guy that tried to move it to Orlando, and they're like, we built this, and we're even going to kind of put it in your face. And then what is incredible, it's an entire, very ornate marble wall, and right above the plaque is the thermostat. And so just another thing there. So again, the most passive-aggressive political plaque that I have seen across the country. I thought I had to share that with everyone. Now, I have been reflecting recently on the preambles to our state constitutions. And in fact, when I was there in Florida, I'll put up a picture of this as well. But the preamble to the Florida Constitution is up on the wall. It's displayed in kind of the top of one of the entry areas. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty, in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all, do ordain and establish this Constitution. In fact, I encourage you, if you've never looked up the preamble of your state constitution, most of the state constitutions here in the United States have a section of gratitude to Almighty God or to Providence. And actually just reading them all together is really encouraging. Certainly, we mentioned the one here in Indiana and Arkansas, they have this unique piece to it, which says, we, the people of the state of Indiana, grateful to Almighty God for the free exercise of the right to choose our own form of government, do ordain this Constitution. And so sometimes we can take religious liberty for granted. It definitely deserves more than a shrug. And you think about we have the opportunity to actually choose our own form of government. How many Christians throughout the ages and even today have that right? And so that was encouraging. I wanted to kind of share that as we jump into this topic, legal challenges in Christian education. Now, this was specifically going to be geared towards private Christian school leaders, but even homeschoolers, those that are interested in raising up the next generation, if your ministry sits kind of adjacent to that. This is all going to be relevant to you. I'm also going to talk about some cultural trends and legal trends. We talked about some affecting the next generation last time. This is going to be a little more legal, political heavy, politically focused, legally focused in this episode. And so this is something hopefully for everyone, but it is focused in on specifically those legal challenges to Christian education, both at the kind of elementary, secondary level as well as higher ed as well. So a couple of thoughts on kind of where we are legally and the the legal moment we find ourselves in. The first one I would mention is that the sexual revolution has shifted from acceptance to enforcement. We've been talking about this for a little while, that it used to be, hey, just accept specifically the LGBTQ community, and let's just make sure we're living together with dignity and respect. And then came those cases like Jack Phillips, who said, look, I will serve all people, I just can't create all messages. And why is it that for someone to feel whole, they have to force someone else to violate their conscience? We've talked about other cases. Mr. John Klug, the teacher in Brownsburg, Indiana, who simply asked, hey, can I just use last names for my students? And that was not good enough, and he was forced to resign over that. And so it definitely shifted from this kind of acceptance phase to, no, you must go along, you must use the pronouns, and you must bake the cake, those sorts of things. So not a novel concept, but that is, I think, the moment we find ourselves in, and it's something that's been pushed back against, and there have been some successful efforts to do that, as we'll talk about. The other one that we continue to see is the curious resurgence of the religious left. And there's Celerico, especially in Texas, who's getting a lot of headlines, the Senate candidate, and he would say, I believe Christianity points to the truth. I also think other religions of love point to the same truth. I think of different religious traditions as different languages. No, and he also goes into basically saying there's no set Christian orthodoxy concerning abortion or concerning same-sex marriage, which just ignores the entire meta-narrative of Scripture, the Genesis 1 created order. And Jesus said, I am the way, the truth, and the life. No man comes to the Father but by me. Those are Christ's words, all right? And so we see this. I say it's a resurgence and not just the rise, because as I've studied this, there has been a religious left present kind of throughout American, at least the after post-World War II history with the main lines, etc. But it has not been as pronounced. Most people would better know the religious right, and so we're now having to deal with these arguments. This is why I look first at what is biblical rather than what culture says is political, because so much of this is not a discussion about, we're atheists and you keep your Christian beliefs out of here. It is, no, what is Christianity? What is truth? What does the Bible say? And this is where, as church leaders and as family leaders and those raising up the next generation, this is not something we can just ignore because the TikTok views, YouTube, etc., folks are, is that what Christianity really means? And we have to have our voices out there as well. Another thing that I am grateful for, I've termed this the uncommon return of common sense. Some might call it a renaissance of the created order, a little bit more flashy way of saying it, but to have executive orders that just say we are male and female. And to see some of these religious liberty cases, to see John Klug actually win his case. So he said, look, I can't in good conscience use preferred names and pronouns. I can't say that which is untrue. I cannot give credence to something. I cannot bear false witness about my neighbor. I cannot give credence to the idea that a male can actually be a female. And he was forced to resign. After 9 years, just settled his case for $650,000. Lots of news media on that. And so that's just, that's an uncommon return of common sense. And specifically in that case, the Seventh Circuit held that the subjectively perceived emotional harm of the students it's not enough. You can't just say, your beliefs harm me emotionally, and that creates an undue hardship for an employer. It has to be actual objective harm. So I'm so grateful for, again, the return of common sense on that. We continued to see unlikely allies, especially in the pushback against gender ideology, specifically the LGB movement. So let's say if an individual is a lesbian, a woman largely defines herself by being attracted to another woman, and if a man can just come in and declare himself to be a woman, that cancels out a lot of what you've worked for. And so it's interesting and has led to some remarkable conversations with folks that I never thought I'd be able to maybe sit down in a room with. And I encourage you, even in your own sphere of influence, that there's a real openness when you're talking about parental rights, to talk with folks that might not normally speak to you as a Christian, or maybe a conservative Christian is how they might see you if you're listening to this, and to be able to open those conversations. I've been able to have several of them, and I'm grateful for that. Now, I don't know if this coalition would survive disagreement over marriage, the definition of marriage, But as we talk about parental rights and gender identity issues, there are unlikely allies in this pushback. And so I think that's an opportunity for us to build relationships, build coalitions on those issues. Last one I'll say here on just developments is that a pen will not save religious freedom. If you're watching the PowerPoint, I also want to put up the USA Today article on Mr. Stephen Ressler, my client over at Hirschberg Law Office. He said, I received a written corrective action form citing my alleged misgendering as the reason for my termination. And my statement there in the USA Today article, IKEA is an international corporation with numerous stores and thousands of employees, and Mr. Ressler simply referred to his coworkers in a respectful manner consistent with his beliefs. And so that's, again, kind of further proof of this. We're moving from acceptance to enforcement, and also hopefully some pushback on that so that Christians can refer to their coworkers in a respectful manner consistent with their belief, but not be fearful of losing their jobs. So the last one, a pen will not save religious freedom. We're all, I'm sure, civically minded enough to know that executive orders can be rewritten, canceled with the stroke of a pen on the change of administration. And so there have been a number of great executive orders, but what we need is Congress to act. Right? We do need the Supreme Court cases to back these up as we move forward. Otherwise, this is just going to be a flash in the pan. We see culture changing, and this is all great, but we've all probably been around long enough to see these things swing back and forth. So a pen's not enough. We need good cases. We need good acts of Congress, acts of state legislatures, etc. All right, so let's dive into 5 key challenges for school leaders or school or educational leaders. So 5 challenges for them. So the first one is define what you intend to defend. This is something I've been talking about for a while. And essentially, as a Christian school comes to court or comes into public life, if there are challenges to, let's say, its hiring practices, that's going to come up in our discussion today, is that you have a religious character, you have a religious mission. And so you need to, in your foundational documents, your articles of incorporation, your bylaws, you're going to want to make sure that you actually line this out. Now, I've explained this over the years, what I would call these jurisprudential bubbles, and kind of in the outermost bubble is the marketplace. And you think of Zork versus Clausen back in 1952, we are a religious people whose institutions presuppose a supreme being. So you could work in the marketplace, you could work in the Christian school, independent board-run school, you could work in the church, and be confident that what you believe is secure. As you move forward into, say, like 2013, and you see the Jack Phillips case, you see the Bostock case, which was a Christian-owned funeral home that lost that employment lawsuit. That in the marketplace, there are challenges to be able to do that well. And then as you move forward to Obergefell in 2015, it's crazy, it's been over 10 years now, that there was a conversation about Christian institutions that had housing for married couples and whether they would be able to say, hey, these couples have to be consistent with our statement of faith. And Donald Verrilli famously said on behalf of the U.S. government, that is going to depend. It will be an issue. And so there continue to be challenges for the independent board-run Christian school of that being an issue. And then the church remains the most protected institution in the American jurisprudence. However, if those forces kind of coming against biblical ideas could go through the marketplace and then the school, I imagine they come for the church next. But gratefully, that is secure now, that we have a lot of protections as a church. So that's kind of where we are. And so as a school, and as really any Christian ministry, if you're a church school, let's say schools underneath the umbrella of the church, you want to file or revise the church articles of incorporation, noting that the religious mission of the church includes daytime education of children, drafting or revising constitution and bylaws, largely to ensure that the spiritual oversight of the church remains over the school. Now, you don't want the pastor, deacons, or even elders having to micromanage how math is taught at 10 a.m. on Tuesday, but you do want to be able to say, hey, anyone that's teaching for our school has to agree with our statement of faith, so that spiritual oversight remains, and organizational oversight even. And then Developing and reviewing teacher handbooks and contracts. I'll explain a little bit further on that one in a minute. Develop or review parent-student handbooks and admission applications. All of that's going to set out. We are a religious mission. We are a religious organization. We base our employment and admission and discipline decisions on that statement of faith, and so you're clearly marking that out. So you have to define what you intend to defend. In all the cases, it's, well, are you a religious organization? How do you prove that? Well, you have your articles, you have your bylaws, you have your handbooks, and you're able to prove that easily. If it is a simple independent school, meaning an independent board-run Christian school rather than under the legal umbrella of a church, you're going to want to file or revise those articles of incorporation. And by the way, I mention this all the time, but if the bylaws and your articles of incorporation conflict, oftentimes the articles are going to control. And so articles of incorporation, if your ministry is incorporated, they're often filed at the beginning of the life of that ministry and often never updated. So they can be sitting in there, 1960s, 70s, 80s. They can have positions like trustees that don't even really exist anymore. And if there's ever an internal conflict or even maybe external pressure, that can come up. And so it's important to go back. This is a drum I've been beating for a while. Go back and update those so they're consistent with how you operate. And you don't have a nasty surprise waiting for you in litigation if it ever arises. So also applying for state and federal tax exemption because churches are automatically tax exempt, but an independent Christian school that is not an affiliate of a church, that organization is going to have to apply for those. Developer reviewing teacher handbooks and contracts in both the parent and student handbooks and admission applications as well. All right, so I know that was super exciting for anyone listening in on the treadmill. Oh boy, here we go. And everybody looks forward to looking at their bylaws. But I have to just really stress for everything that I'm going to talk about, that is so important. You have to define what you intend to defend, including in your statement of faith, what you believe about marriage, sexuality, etc. Another development or challenge that I would say for those in the Christian school. And this one's interesting because in public life, everything that we do has implications, sometimes unintended consequences, even if it's a really great ruling. And so this goes back to a case called Mahmoud versus Taylor. This was a great Supreme Court case. Parents in public schools saying, look, we have to have the right to exempt our kids out of sex ed, especially if that sex ed class is going to have information, is going to have books, topics that are going to be inconsistent with our beliefs. And what I'm referring to often is maybe very early. It can be first grade, second grade. There are all of these resources that are put out in children's books. Like I think one is called The Prince and the Knight. And so it's seeding these ideas about you can't trust your biology and going against what the Bible says about human sexuality very, very early. And so parents said, hey, we want to exempt our kids from this. And the school's essentially like, no, this is necessary curriculum, teaching the kids what they need to know about the world. And so that went up all the way to the U.S. Supreme Court. The U.S. Supreme Court ruled in favor of the parents exempting their kids. Now, the challenge has come, though, in other states. For example, I'll mention California. So if you have, say, like a licensed preschool in California, my understanding is that the parents themselves, they can opt the kids out of religious instruction, right? This is also true in the state, or has been true at least in the state of Wisconsin, for schools receiving vouchers, that parents could actually exempt their kids out of religious instruction. Well, if you're a Christian school, what's the most important class of the day, all right? And doesn't that interfere with the educational religious mission of the school? And what I've seen some schools do, or what has come up before, is if schools send home a form to say, look, parents, you can opt your child out of sex ed. Maybe there's a purity class or something, the different classes that will teach about this, or health that may go into essentially, human sexuality, but from a biblical perspective. And parents can say, hey, I want to do that at home. And so the Christian school often in some states would require this, that form go home to the parents, and the parents say either I want my kid in there or I don't. Some states are opt-in, some states are opt-out. Well, what has occurred is putting that form, the sex education opt-out form, alongside a form that says that the parents agree with the school's beliefs on human sexuality. And so if you put those two together, it can look like the parent could just say, hey, if you're in chapel going to be talking about human identity issues or Genesis 1, whatever, that I want to be able to exempt my kid from that religious instruction. And so this idea of, from Mahmoud versus Taylor, parents can exempt their kids from materials that they don't want them to listen to or be a part of. This is getting conflated into, parents can exempt their kids from religious instruction, specifically if you have any ties to a state program like vouchers and ESA, etc. So we need to be very clear that, over here is health class or sex ed. And if parents are not comfortable with that, you can exempt your kids out. We would want to do that anyway, out of deference to parents. But then over here is the biblical teaching, the religious instruction that our school does, and that's a necessary part of the curriculum. And the state really has no business telling a Christian school, hey, you have to let parents exempt out of that as part of your operation. That's just interference in the school's mission. So that's one that was a little surprising to me. I am grateful for cases like Carson v. Macon, Espinoza, that does say, look, if the state is operating a program, it cannot kick folks out of that program based on their beliefs. And these like opt-out of religious education provisions hopefully get challenged under those rules, and eventually that gets cleared up. But that is happening right now. So not one that I had expected, but it is occurring. The next one I would say is encouraging developments in girls' sports. Many of you are probably familiar with the executive orders on this, saying that, look, Title IX is really about female sports, and females need to be able to play sports, and we're not going to have males participating against them. And that is simply a biological reality, and biology isn't bigotry. Zach Elliott over at the Paradox Institute, we talked about this in the discussion, has a great video just comparing a male and female, same age, even same weight, but all of the God-given differences. And we're different in that way, but equal in dignity. But God has given us a wonderful purpose and has designed us differently. And so our law should just reflect that creation order reality. And so one of the things that had come up was Mid-Vermont Christian School was actually kicked out of the Vermont State sports program because they declined to play against a school with a male on the team. And that they pursued that in federal court. Eventually, the Court of Appeals for the Second Circuit granted a preliminary injunction that overturned a previous ban and allowed that school to rejoin what's called the Vermont Principals Association so they can continue to compete. And my understanding is that girls team actually ended up going pretty far in kind of the end of year tournament play. And so that's encouraging. And unfortunately, that continues to happen there. Also, if you had watched the case of BPJ and Hecox, there were oral arguments on this, and there was this really striking moment, and it seemed like the justices were favorable to women's sports and tightly defining Title IX. But there was this moment where the ACLU's attorney, Joshua Block, was asked about the definition of sex, and he was, in a sense, kind of refusing to articulate what sex means under the law. And so it kind of resisting offering a clear definition on this. And I thought about if we could slap Romans 1 on any issue in our society today, it's this: like, we can't define what male and female is. So I think that's definitely a Romans 1 type of thing. We have educated ourselves into ignorance. The next one, and this is hopefully worth the price of admission here, right? Really, it's the time. And by the way, especially for our longtime listeners, those that tell me, hey, I tune in every week, I take that very seriously. Your time is the most valuable thing that you have, and the fact that you would tune in as we talk through these really important issues, I certainly am blessed by that, and I take that seriously. So this next one, I would call it maybe the expansion of the ministerial exception or the expansion of legal protections for ministries, and it's along the lines of ministerial exception, the right of ministries to hire and fire their employees. Now, I wanted to take just a second to dive back into this so that I can explain what's happening, because this is really, really important. If you remember back to the Bostock case in 2020, Bostock essentially said in Title VII cases involving the Civil Rights Act, Title VII addresses employment, that an employer may not discriminate against an employee based on sex, which would be under 1964. You can't discriminate based on sex. But then Justice Gorsuch wrote that opinion saying, well, but sex it should be interpreted to include sexual orientation and gender identity. Many conservative legal scholars are, jaws are still on the floor that was written. And one of the challenges there was the opinion did not address how it would affect religious ministries. So it set religious ministries up for years of litigation. So on top of addressing those in the marketplace, it didn't address ministries. Now, as we've discussed before, the U.S. Supreme Court turned around just a few weeks later in Lady of Guadalupe and strengthened what is called a ministerial exception. Now, when I think of minister, I think of pastor, but this is much broader. The case involved Christian school teacher. And so anyone that is tasked with communicating the faith to the next generation, that person is a ministerial employee, and the ministry has the right to hire and fire that individual. That often is a jurisdictional bar where you can just outright dismiss the case. Sometimes it's an offense that you can raise, but it is the strongest legal protection. And so we've talked for years about memorializing those spiritual responsibilities that Christian schools give to their employees. So many of the schools that I know, everyone is pitching in, helping with training up the next generation, modeling this. But the question that has lingered since 2020 is, what about the employees that don't have a teaching function? So let's say it's just the janitor. Let's say it's someone helping in the kitchen, and their gifting to the body of Christ is through that. And by the way, I wonder sometimes if the janitor's cleaning all the toilets, they're going to have more jewels in their crown in heaven than I'm going to. And so grateful for these people. But maybe their skill set, the way God has blessed them, is just not teaching. It is serving. Well, does a ministry have the right to hire and fire those people according to their statement of faith, or can they be forced to hire folks that are inconsistent with their beliefs? And this is completely illogical to me. All right, if this is a mosque, if this is a Hindu temple or something, should they be forced to hire workers that don't believe what they believe? This seems absolutely contrary to the First Amendment and the right to free exercise, freedom of association. And so what has happened, there's a Union Gospel Mission case. This would be out in actually the Ninth Circuit. So everyone just, maybe grab something. You may need to be sitting down, but the Ninth Circuit got this right, all right? And actually there have been some good opinions coming out of this circuit. And what they have ruled on is what's called the church autonomy doctrine. So I want to add an additional legal doctrine here today. So the ministerial exception, anyone that's teaching the faith to the next generation, they are exempted from these non-discrimination laws. But that ended really with, those that are teaching the faith. That's that that's that legal doctrine. What the Ninth Circuit kind of hung its hat on is what's called the church autonomy doctrine. And let me read a little bit from the Union Gospel Mission case. And I think it's going to help maybe pull together a few things. So the church autonomy doctrine encompasses more than just the ministerial exception. It forbids interference with an internal church decision that affects the faith and mission of the church itself. In this case, Union Gospel's co-religionist hiring policy, meaning the ministry hires co-religionists, people that share their religion, co-religionists, constitutes an internal management decision that is essential to the institution's central mission. It is uncontested that, one, Union Gospel is a religious institution. Side note, how do you think they proved that in court? Well, their articles, their bylaws, their handbooks, proving their services, all of that. Union Gospel has a sincerely held religious belief that only co-religionists may advance its religious mission, and 3, Union Gospel's co-religionist hiring policy is based on that religious belief. Under the church autonomy doctrine, Union Gospel may decline to hire as non-ministerial employees those who do not share its religious beliefs about marriage and sexuality. Boom. All right. There's the question left by Bostock answered by the Ninth Circuit, saying, if your church or your ministry says, and by the way, this is a Union Gospel mission, it's a ministry, it has a religious mission. It's a religious institution. They have a belief that, hey, our mission is going to be carried out by those that share our faith. Novel idea, right? And that hiring policy is based on that. And so Union Gospel won. Now, move over to the Fourth Circuit. And so there's a case involving Liberty University and an individual that actually had kind of completed their probationary period. This is called Zinsky versus Liberty University. And so it's an individual that had finished up their probationary period and then actually decides to transition to identify as female. And so then this individual sued Liberty University, saying that, look, they can't discriminate against me. This is a Bostock issue, right? And just to put, kind of put an exclamation point, I might say, an exclamation point behind this. Let me just read to you. Here's the question. People sometimes say, no, I mean, they're not coming for our religious beliefs. It's kind of a live and let live thing. Well, Judge A. Marvin Quattlebaum in the Fourth Circuit posed a hypothetical question to the advocate Matt Staver, representing Liberty University, whether a Christian church of 16 employees, one of which is a janitor, must hire a transgender employee, even though their beliefs would be contrary to their doctrine. Apologies. So this was a question actually asked of the ACLU attorney, Matthew Callahan. So he's basically saying, look, can they be forced to hire a janitor contrary to Liberty University's beliefs? And ACLU attorney Matthew Callahan said, yes, they must hire that individual because applicable employment laws are neutral and must be obeyed. All right, so there you have it. I mean, there's the very clear position that is being taken. Anybody that is not on the ministerial staff, you have to hire people that are inconsistent with your mission. All right, this again flies in the face of the First Amendment, and so this is the case to watch in the Fourth Circuit, Zinsky versus Liberty University, but. Hopefully, the church autonomy doctrine prevails there as well. Maybe this ends up at the Supreme Court. But the position here is that ministries do have the right to hire and fire everybody. I fall back on, the First Amendment to the Constitution on that. And that's being worked out right now. So it's good to see the Ninth Circuit decision. And again, that's probably the most important thing. If you're in job descriptions, in contracts, that you are clarifying all of the ministerial responsibilities, meaning the teaching, the praying, the assisting of the religious mission and teaching the next generation. The one other issue that I'll mention is parental rights, or persistence pays off on parental rights. And then I have kind of one add-on. I've said there's 5. There's one add-on that has been a topic of major discussion in recent days. But persistence pays off on parental rights. Many are familiar, if you've been listening for some time, that here in Indiana we had a major parental rights case. We turned around, became the first state in the country to pass a law that simply says that referring to your child consistent with their sex cannot be considered abuse. But one of the challenges that we see across the country, certainly here in Indiana as well, is efforts to change gender markers. So that would be a birth certificate. And the legal process is going to be different at different places, but largely a state-driven legal issue. And the parent can come into court, or there can be even a less stringent way to do this. And basically just saying, look, this is in my child's best interest. Maybe have a doctor's note. And to say, here, my boy is now a girl, and we're going to change the gender marker on the birth certificate. Well, what happens when a Christian school is trying to maintain an admission policy consistent with their statement of faith about male and female, and an individual presents with a birth certificate that is contrary to kind of the obvious, sex of the individual, of the student in front of them, and so that is a challenge. And so defining in state code or even in federal law, here's what sex means: is male and female. These are bodies organized around male or female reproduction, as we've talked about before. But persistence has paid off. Also, the Bonta case recently, the secret transition cases in public school, where the school was hiding from the parents that a child would come and declare themselves to be a gender different than their sex. And that was being hid from parents. And the Supreme Court, in an initial way said, no. Parents have the right to the care, custody, and control of their kids. The religious upbringing, you can't hide this stuff from them. And so we are seeing some pushback on parental rights and some success. So there are times I get on here, and I was even sharing with the group this week, what I present. It's like, I'm really sorry. I just have to tell you what happened. All right. That's my job. But this year, there's been a lot of encouraging developments. So those were the 5 key legal issues, but I wanted to add on another one. Just if you're a Christian school leader, and really for really everyone that is interested in training up the next generation, is this federal education tax credit. I won't go too deeply into this today, but essentially in the big, beautiful bill, it allows for a dollar-for-dollar tax credit up to $1,700 for donations to state-approved scholarship-granting organizations starting in January 1st of 2027. And so you're seeing states begin to opt into this program. And essentially how it works is there will be essentially federally recognized SGOs, scholarship-granting organizations, and individuals, anyone could give, it's a dollar-for-dollar credit. So $1,700, and then you get that off of your taxes. That money goes from private individuals to a scholarship granting organization, often a 501c3 or a freestanding organization, and then that organization can pass it through to a Christian school, and that school can provide scholarships to students. This money can be stacked on top of existing vouchers and ESA, educational savings accounts, to help with private education. And I bring all of this up because as we get closer to January 1, I suspect there's going to be a lot of communication about this. And for Christian school leaders, there are going to be a lot of questions about, do you participate? And then how can you get people to donate to this? And so like any partnership or opportunity to be funded and to have, this is essentially maybe a tax assisted or favorable. This is not a voucher program where money comes directly from the Treasury. Rather, it is private donation to an organization that then goes through to the school, and essentially it's just a tax credit. And so there are going to be questions about should your school participate in that, and there's a lot of discussion about what about any strings attached, religious liberty concerns. And we do have the Fulton case. I mentioned Espinoza as well, that essentially if the government has a program, it can't kick people out over their worldview. And so there is protection even for voucher programs. And then you kind of take this is even more protected in the sense that it's a tax credit, essentially, that's just flowing through to these schools from individual donors to an SGO to approved schools. And so I'm sure you're going to be hearing more about this program. Like any organization or like any program like this, I'm going to leave it to the conscience of school leaders, their particular situation, whether they think this is a good fit for their ministry. But I'm sure you're going to be having folks contact you if you haven't already. I'm sure many of you have, but I did want to at least mention it's a challenge. It's also an opportunity, all right, like many of these. So those are the issues, the challenges for Christian education that I would see in 2026. We did one in 2025. I wanted to update us for this. So as I come to a close for today, I just have a disclaimer. Of course, I've covered a lot of legal topics, but this does not form an attorney-client relationship. And so you can see the disclaimer on the slide, but also it plays at the end of the episode as well. If legal advice or other expert assistance is required, services of a competent professional should be sought. I also wanted to mention, if you're over on YouTube, if you haven't signed up for our email updates, or if you're listening, we can include that in the show notes where you can go and sign up. And you'd like to see some of our emails as we just try to keep you updated that way as well. You can have a QR code where you could sign up for that real quick. So I mentioned a story that just really encouraged me this week. And so I was at this principal's clinic, and I had a chance to have dinner with some of the delegates. And I think just providentially, I sat down at a table, and I was eating with a principal and his wife from Mexico. They're a group of Christian schools there. They're kind of a leading Christian school, and they have a number of others there that they oversee, and then a school leader from North Carolina. And I'm just sitting down, getting to know them, and I come to find out that both of these individuals, their ancestors, their families, actually came from around the same place in Ukraine, Crimea, and that both of their families, ancestors, actually left in the rise of Leninist communism in the early 1900s. And they saw the writing on the wall that if they stayed, they were not going to be able to practice their faith. And so the individual from Mexico, his family had moved to Canada and then to Mexico. The individual from North Carolina, his family had moved to Pennsylvania and then to North Carolina. They had never met each other before. They're here. They're there at this conference, and they're just talking and find out, wow, our ancestors, our families actually came from the same place. And so it just struck me once again. I talk about this from time to time, that God is at work across continents and ages. We get to play a small role in building his kingdom, God's great plan to redeem humanity, redeem the world. And it just kind of sent chills down my spine of thinking about that. But it also, as I was reflecting on it, reminded me that individuals have literally crossed oceans to be able to do something simple, train up their children in the nurture and admonition of the Lord. And sometimes we, I think, can take for granted the religious liberty that we've been given. And there are challenges, right, that we talk about. But as you think about these other stories, that people literally have crossed, halfway across the planet to find a place where they can worship God, where they can raise their kids. And it just left me with a profound gratitude. As we're celebrating our 250th, I want to be more intentional about just being grateful for what we have. And I will close with that today, that, there are years where I come on here and, man, this is hard, but a lot of great encouraging developments. And then just grateful for the place God has placed us and the opportunity that we get to actually put into the next generation, into Christian education and raising up these kids in the nurture and admonition of the Lord. So that would be some legal challenges in Christian education in 2026. We'll be back with you next week.